Hello, lawyers and law students, wherever you are in the world. This is Catherine from Cambridge Law Studio. We are specialists in English, especially for lawyers. If you would like a certificate in legal English, if you go to our website, Cambridge Law Studio, you'll find online study packages, and you can also do the exam online. And at the end of it, you get a certificate. Back to today, please download the free legal vocabulary PDF. Welcome to our quick legal vocabulary class. Fiduciary duty. Most lawyers will discover the words fiduciary duty when they're working in company law. This is because a company director has an automatic legal duty to always act in the best interests of the company. What does that mean? It means the director is obliged by law to put what's best for the company before what's best for them personally. Okay, imagine for a moment I am a company director and you, all of the lawyers and law students listening, are shareholders in the company. When you chose me as a director, you were trusting me to do what's best for you, the people who have invested money in this company. This means the law describes me as a fiduciary and I owe a fiduciary duty to the company. Okay, before we read this one, let's have a real example where you are shareholders in a company and I'm a director. And let's say we've created a fast food company, something like McDonald's or Pret a Manger, something like that, where we're going to have little fast food restaurants all over the United Kingdom and eventually, we hope, all over the world. That's our situation. Now, you have invested your money in this business and you're trusting me to make a success of this new fast food company. Okay. It may be that as a director, a situation comes up where I have a conflict of interest. This means I have to make a choice between what's best for me and what's best for you, the company, the shareholders in the company. And we have many examples of court cases where a company has taken legal action against a director like me on the grounds of breach of the fiduciary duty. An example, we've just started a fast food company. You've invested your money. What's the conflict of interest for me? Well, we need a fast food outlet on Oxford Street in London where we can sell food to all of those tourists who always come to Oxford Street. It's almost impossible to buy a shop on Oxford Street now. We're going to have to rent. So, as the director, I'm going to choose number 10 Oxford Street, okay? And you trust me. However, number 11 Oxford Street was a bit cheaper and a bit better. Why did I choose number 10? Belongs to my sister. My sister is going to receive the rent. I had a conflict of interest. What's good for me and my family and what's good for you. I just chose what's good for me. I breached the fiduciary duty. And you, if you discover it, you have to discover it. Take me to court. That's the solution. So let's look at some examples of the different types of breach of fiduciary duty. The first type of breach is called self-dealing. When a director self-deals, it means something like, I misuse the company's money to buy things for myself. For example, a holiday or a nice car. That's your money, and I'm having a really nice holiday and a nice car. That is self-dealing, and it's a breach of the fiduciary duty. Or the example we just had, the company needs to buy something that I or a member of my family produces, and I award that contract between the company and the person who produces what we need to myself or a family member. So if we go back to fast food, the fast food company needs a tomato ketchup and barbecue sauce provider for all of the United Kingdom. The company needs a contract to buy tomato ketchup and barbecue sauce. What I should do is check everything and get the best deal I can for the company. But my father has a factory that makes barbecue sauce. I'm going to award him the contract. That's self-dealing. The car, the holiday, and the manipulation of the contract to a family member. If my father was really the best for the company, that's different, but I still have to declare it so that everyone knows it's happening. So it's quite easy to breach the fiduciary duty if you're kind of a bad person, and a lot of company directors are. The next thing I might do after self-dealing is usurp. Wow, that's not a word that most English people use every day. Usurp a corporate opportunity. That's legal English. Usurp means to take something wrongly. I take something, I seize it, and I should not have done it. So there's an opportunity for our company, and I take that opportunity for myself. So, for example, let's imagine the Olympic Games are going to be in London soon. They're not, but we'll imagine they are. And the Olympic Committee says we've got 15 sports stadiums around the country, and we're looking for people to supply fast food. This is a perfect opportunity for the company that you invested your money in. But I don't do that. I create a new business just for me, and I get that contract. That is usurping a corporate opportunity and a breach of the fiduciary duty. The next possible breach of fiduciary duty is negligence or mismanagement. The company and you, because you are the company, expects me to be diligent. That means be very hardworking and to do my best in every situation and to carry out my duties with reasonable care. If I am negligent, meaning I'm just not careful enough, and the company loses money as a result, that is a breach of the fiduciary duty. For example, I don't notice something is wrong with the company's financial accounts. So to be negligent, you're not doing something deliberately wrong, like buying yourself a holiday with company money. You're just not careful enough. And if we're very successful and we have millions of pounds coming into the company accounts, and I don't notice that the company accountant is dishonest and he is taking money for himself in bigger and bigger and bigger amounts, I'm negligent. I have to check these things. So, to breach the fiduciary duty, you don't need to deliberately do something bad. It's possible to breach the duty by just not being careful enough. Negligence. Another example, see all these things that directors can do wrong. Another example is a director disclosing, which means telling, speaking, the confidential information of the company. For example, I see an opportunity to make some money by sharing information about the company's intellectual property, or even selling our customer database to a competitor. I'll give you a silly example. Our restaurants become famous for the quality of the fried chicken. Excuse me, I'm going to have a drink of water. Our fried chicken is amazing, and all of our competitors, including KFC and Nando's, and any fried chicken outlets you have in your country, they all want the secret. And because I'm a greedy idiot, I sell the recipe, because that recipe is our trade secret, it's our intellectual property, and I sell it because I'm a greedy idiot. Or we have a database of customer emails, and we use that to email special offers and coupons and things, and I sell it to a competitor because I'm a greedy idiot. And you'd be surprised at how many company directors and politicians are greedy idiots. And that is a very serious breach of fiduciary duty. Your salary and your bonus should be enough if you're going to be a company director. And if that isn't enough, don't be a director. But we've got hundreds of cases in courts of directors doing foolish things like this. The thing is, what can you, the shareholder, do about it? Let's take a look. So this is called a remedy. The court provides you with a remedy. It means a legal solution to your problem. So what can you do? One remedy for breach of fiduciary duty is to take legal action against the director to recover, which means get back, lost profits. So if you can prove to a judge that the company has lost profits because of my breach of fiduciary duty, the court will order me to return those profits, even if that costs me my house. Pretty good. Do you know what rescind means in contract law? When the court rescinds a contract, they basically put each party back in the position they were in before they entered into the contract. So if you look at my contract to rent number 10 Oxford Street from my sister, I think I said, the court can say, nope, it's a 5-year contract, but stop, terminate, you return the rent, you return the premises, the contract never existed. So that gets you back the money for the rent I've already paid to my sister. When you rescind, the parties are returned to their original position. So that's quite a good one to ask for. Another is to ask the court for restoration of property. Restoration means return. So return what you gave. Return that car. Or pay its value. You can either give it back or you can pay the value. You have to choose one. So there are a lot of things that a company can do against a director who goes a little crazy and does these things. That is what fiduciary duty is. Act in the best interests of the company, and if you don't, the shareholders and the company can have their day in court to recover lost profits, to rescind contracts, and order restoration of property. Let's just finish by saying we hope this also applies to presidents. Say no more. Congratulations! You can now use the words fiduciary duty like a legal professional. To practice these words and more for free, download the PDF. It's part of our A to Z of Business Law book. You can buy that book as a PDF on our website. It's not that expensive. And if you would like a legal English certificate, go to cambridgelawstudio.co.uk. You'll find study materials and how to do those exams online. See you in the next one. Bye bye.